Yes, hi everyone, this is the School of Fetish, and in this video I will talk about unjust enrichment. I just wanted to issue a disclaimer that nothing in this video should be regarded as legal advice, and nothing here reflects necessarily the latest legal developments. Now, the case that I'm going to discuss in relation to unjust enrichment is the case of Meneleu versus the Bank of Cyprus Ltd. The facts of the case were about the Meneleu parents, and they were basically a couple. We're going to be calling Meneleu parents for practical considerations from here on. They had a property, the property located at Rush Green Hall, and they had also a debt towards the bank, which was the innocent party, and they wanted to sell the property for more than £2.2 million, so they could repay the loan to the bank, because the bank had charges over that property, and buy a smaller property and certain other family gifts. However, they couldn't find a person who was willing to purchase the property for more than £2.2 million, and they would still have to go on with with a purchaser that they found who was willing to purchase the property for £1.9 million, and the transaction would have still gone through. They would have still purchased a smaller property for themselves, but it was going to be with the difference that the bank would have had a charge over the new property that they were going to buy for themselves, so they could live in, and still a huge part of the loan balance was going to be repaid by the sale of the main property they used to live in. The lawyers exchanged contracts therefore with that purchaser, and they informed the bank that on the 12th of September 2008 the completion date was going to take place. In the meantime, they spotted another property, the one that was located on Main Oak Tree, and they paid the deposit for that property out of the deposit they got from the sale of the Rush Green Hall property. So the bank, they approached the bank, and they informed the bank that the completion date was going to be on the 12th September 2008, and the bank agreed upon two conditions. The first condition was, and this is where the benefit and the detriment that was suffered takes place, and that's where the discussion and most of the debate revolved around, because that was the transaction that was key as to whether there was an enrichment or not, and from there on, whereupon the Court of Appeal built its argument that since this certain situation happened, then subrogation was also possible, and a potential prospect to be applied in order to reverse the unjust enrichment situation. And the bank said that it was only going to release its charges over the Main Oak Tree property if it received £750,000 towards the balance of the loan, and secondly, only if it was to obtain a charge over the new property that was going to be registered under the name of the youngest daughter of the Meneleu parents, was Melissa. And the bank, of course, as I said, this was a mandatory for the bank because it wanted to protect its interests. The bank would stand to suffer a lot of detriment. It would just risk being in a very bad situation had it released its charge before it received that kind of money, because it could have just been spent on the Meneleu parents' personal whim for any personal reason. So in that situation, they would have incentivized the purchasers who were at pains to have the charges released from their property, so they could have obtained a clean title, to make sure that they would have obtained the £750,000 through their client's account by sending them to their solicitor, rather than the case would have been where the Menaleo parents could have just spent the money on a personal way. Also, the bank would have wanted the risk to fall on the purchaser, who would have been the party who would have had to sue the seller, who were going to be the Menaleo parents, if they didn't transfer the property, and therefore the mortgage couldn't have been obtained in favor of the bank. And they would have had to sue for their money back. So the bank had all these reasons to be in a position not to want to release its charges before these safeguards were in place. The bank wanted also to make sure that before it released its charges, that it had obtained a mortgage. So there was, because the mortgage was also cataloged in Her Majesty's Land Registry. So there was nothing to really make the bank suspicious that maybe a mortgage couldn't have been obtained, because unfortunately it turned out to be the case later on. Everything was in place, and that transaction was mandatory. Had the bank transferred the benefit, or had the bank provided physically the money, so it could basically say that it was going to subrogate itself into the vendor's position, then it wouldn't have had to go through that transaction. And that very transaction shows that there was no money was actually offered by the bank. Quite the opposite had happened. And this is implicit in the analysis of the Court of Appeal, that they don't just focus on subrogation, but they keep going back to the unjust enrichment argument, that the order of things had nothing to do. There was, because the bank through its actions, if the bank hadn't, basically the rationale of the court was that the court justified the disorder between the benefit and the detriment that was suffered based on the fact that the bank had already on the 9th of September 2008 wrote a letter to the Menaleo parent solicitors that it wouldn't have released its charges until these two conditions were satisfied first. And also the Menaleo parent solicitors on the 10th of September obtained a certificate that was saying that they were going to execute a charge in its favor. So the court's argument is basically that the bank had already promised, and on the faith of that promise, the transactions took place, because the purchaser, on the strength of this promise, on the faith of that promise, decided to purchase the property, and then this allowed the fund of the sale to be provided to purchase the new property, whereupon the benefit was transferred. And the benefit wouldn't have been transferred if the bank hadn't made these promises. So what happened in the end was that the solicitors for the Menaleo parents, they executed a certificate for the bank that they were going to execute a mortgage in its favor under the name of Melissa. The main Oak Tree property was transferred to Melissa, and the bank released its charges right after a month. A mortgage, it appears that a mortgage wasn't signed by Melissa, it was signed somehow unusually by her brother, so no mortgage was ever obtained, even though it showed on Her Majesty's Land Registry records, computer records. Just because the fact that it suffered the detriment technically after it released its two charges over the Rush Green Hall property, this didn't make it any less at the bank's expense. It didn't make it lesser unjust enrichment than other cases. It was just a mere formalism that this basically happened. And this is a really good point. This is a really good argument, and it's the argument, the commercial sense argument, that this is the argument that prevailed. This is basically the case. It turned out to be that the Meneleu parents weren't performing well on their loan, and they wanted to repeat the same thing over, sell their property at Main Oak Tree, and repay a huge part of their debt to the bank, and from there on buy an even smaller property. But Melissa would have had to be informed, because she was the person under whose name the property was registered. The conveyancers pointed to the mortgage. Melissa didn't like it because she was informed that she never signed the mortgage, and therefore she sued in order to rectify this mistake on the land registry's computer records, because the reality of the situation was that somehow Melissa never signed the mortgage, but it was her brother upon the instruction of the Meneleu parents' solicitors. Why this case was so important? It was important because it was a case where unjust enrichment, like on a moral basis, everything basically screamed that it was definitely an enrichment. The person who got enriched at the expense of the innocent party received a huge profit, and that he didn't even lift a single finger to create on his own, and would have been really unjust for it to keep the benefit that was transferred to him. What was missing from the case, and what raises certain legal considerations, further legal considerations to be thought over, was that the detriment was suffered after the benefit was transferred. So it seems that there was not enough of a causal link between the detriment that was suffered and the benefit that was transferred, and the defense basically capitalized on that issue in arguing that there couldn't have been an unjust enrichment, because if the benefit was transferred before the detriment was suffered, then this wouldn't be any different from the remainder of the cases where there was no causation between the detriment suffered and the benefit that was transferred, because it shows that this transfer of the benefit wasn't the expense of the innocent party. And how could it be at the expense if up until he suffered the detriment before he transferred the benefit, he had not suffered any detriment? And maybe I'm saying, since unjust enrichment is such a loose principle, and since it derives itself from the law of equity, it's more concerned with justice being done rather than being concerned with the applications of legal principles that are a lot more rigid and a lot stricter and don't allow too much room for wiggle. Apart from that, on a separate consideration, subrogation was considered, and it was stated by the Court of Appeal, as opposed to the Court of First Instance, that the bank could subrogate itself into the vendor's lien, the vendor being the person who, under a certain transaction that I'm going to explain further, was going to sell certain property to the innocent party, which was the benefit that was going to be transferred to the enriched party. I'm sorry, not the innocent party, the enriched party. He would have had a lien on the property, and if he wasn't paid the money for the property, basically he would have had a lien and would have been able to sell it. And since the bank was the party whose at expense allegedly the money was provided, then they would have to subrogate themselves into the vendor's position and therefore have an unpaid lien. Even though strictly there was an enrichment, because the court found that the bank had provided certain money through its actions, then it had problems also with regards to subrogation, because the bank hadn't physically provided that money. So it had to resort back to where the argument that it made with regards to unjust enrichment, that the economic reality was that it through its actions it provided the money for the property, the benefit to be transferred to the enriched party. But that really doesn't solve the situation to its core. And the reason is, what I see is, of course, there shouldn't be another way. That was the economic reality, but there's still one issue that remains outstanding, and this is that that very transaction, the fact that the detriment was suffered after the benefit was transferred, was actually mandatory. It was actually axiomatic for the bank to do that. And this was because of the fact that this order of events wouldn't have happened if the bank had physically provided the money for the benefit to be transferred, which it hadn't. And I'm saying that maybe the fact that the benefit was transferred before the detriment was suffered should extend over to the possibility and the potential of finding subrogation, because it is because of this because of the fact that the bank couldn't provide any funds that it selected. It wasn't anything coincidental. It wasn't anything accidental. It selected this order of events. It selected to transfer the benefit before it suffered the detriment, so as to be able to cover itself. And so it wasn't anything accidental about this transaction. And there we see the paradox that definitely the bank, based on this transaction, didn't provide any money for the benefit to be transferred to that party. So this basically finds logic in the Court of First Instance decision. It's basically that because of the fact that the bank didn't provide physically the money, that it chose this kind of transaction. Remember, there was basically a benefit transferred and the detriment wasn't suffered up until actually after a month. I just find it a little bit difficult to understand the Court of Appeals logic when it says that the bank had tied itself to the agreement that it made when it basically sent a letter on the 9th of September 2008 setting two conditions upon which it would release its charges over Russ Green Hall. And the argument and the aspect that this transaction occurred, which was basically for basically as a substitute to the provision of money for the purchase of Main Oak Tree. This is basically an indication that it wasn't a matter of subrogation, and this is also basically shows that because of the problematic relationship, I just find it a little bit difficult to understand the Court of Appeals logic when it says that the bank had tied itself to the agreement that it made when it basically sent a letter on the 9th of September 2008 setting two conditions upon which it would release its charges over Russ Green Hall. And the argument and the aspect that this transaction occurred, which was basically for basically as a substitute to the provision of of money for the purchase of main oak tree. This is basically an indication that it wasn't a matter of subrogation, and this is also basically shows that because of the problematic relationship between the benefit and the detriment with regards to finding unjust enrichment, and it's not coincidental that just because unjust enrichment wasn't basically at that point the unjust enrichment wasn't at the expense of the bank. It wasn't coincidental that subrogation basically, according to the court of first instance, couldn't apply to the facts of the case. It was just basically because this one single transaction that the bank wanted to make sure that before it suffered the detriment, it had all its charges over Rush Green Hall, and that the bank basically there wasn't subrogation because this transaction happened. These conditions were set just because the bank hadn't provided any money, and just because the bank hadn't provided any money, there couldn't have been anything at the expense of the bank. Thanks very much for watching. This is Dimitris Koulaferis. If you liked the video, click the thumbs up. The citation for the case is I inserted here down below, and subscribe to my channel for more videos like that. I'll see you all in my next video.